These have been long days, and I really appreciate your patience and the way that you followed. I was inaccurate in a statement I made to you, and I want to correct it immediately. That had to do with the hairs found on the Rockingham glove. Detective Furman, in checking the transcript at 34923, was in fact eliminated as the donor of that Caucasian hair, and that was an accuracy on my part. And any time, I've tried very hard to key everything to areas of the transcript, and if, obviously Ms. Clark, I'm sure, will bring any inaccuracies to your attention. If there are any, try very hard to do that, and you should have the testimony reread. You shouldn't misread things like I just did. Another thing I forgot to mention about the Rockingham gloves, however, both gloves, and that is that they found a limb hair. This Caucasian hair is not accounted for to anybody, but there is a limb hair that was found inside the glove. Now, if Mr. Simpson had had these gloves for 4 years, as the prosecution contends, then there should have been more limb hairs. One thing that you saw, and when you saw his hands, and that is that he has a lot of hair on this part of his fingers. And if these gloves had been worn for 4 years, you would expect to find a lot more of this limb hair inside the gloves. But you don't find that. So that's another point to consider that I left out. One quick point here on, do you remember Ms. Clark talked about a blood drop that landed on Mr. Goldman's boot, number 78, that on RFLP testing turned out to be a mixture of Nicole Brown Simpson and Ronald Goldman. And Detective Lang had offered a theory to you that this mixture could have occurred because one knife had committed both of these acts, and there was a combination or a mixture on the knife, and the blood drop fell and hit Mr. Goldman's boot there. Now, the first point to be made about that is the photograph you were shown was Mr. Goldman's boot being lifted up at the time that his body was taken over into the walkway and the coroners were taking pictures of it. If you look back at the photographs and you see the way his shoe was configured, it would be extremely unlikely that one drop of blood could hit because the shoe is at an angle. You couldn't have a drop that would fall in exactly that place in exactly that way, or it's extremely unlikely. But the other thing about this so-called mixture, mostly Nicole Brown Simpson and less of Ronald Goldman on the RFLP probes, is Dr. Lee addressed this, if you recall, when he pointed out the bag in which the boots were taken. Do you remember that? This was the wet transfer of blood coming through the bag here. When these boots are taken off and it's dragged into an area where there's blood from both victims, and then the wet blood is put into the bag, any kind of typing that you're going to get, if there's a drop on that area from a mixture, the DNA test is suspect when you handle the evidence in this fashion in terms of getting a mixture. So that's a point for your consideration, I think. Now, what's left in this analysis is the Bronco, the Rockingham glove, some short final remarks, and you'll be hearing from Mr. Cochran. The first point I'd like to make when we talk about the bloodstain patterns in the Bronco has to do with something that Ms. Clark said, first of all, about the blood drops in the foyer in Mr. Simpson's Rockingham residence. If you recall, in her closing argument, she said, and I don't know how could she say this in terms of the record, that the blood drops that were found in the foyer, you recall there were 3 that were recovered by LAPD, and then when Dr. Lee went back there, he found another 3 smaller cast-off type drops. And she said, well, those drops couldn't be made by a cut on the side of the finger, comparatively superficial cut on the side of the finger. It would have to be made with a major cut or that fishhook type cut, because that's their theory, right? That there's this fishhook type cut on the knuckle that nobody sees. Nobody sees. No one. On the way to Chicago. But Dr. Lee testified about this at page 43022 of the transcript. Question, and he's talking about the blood drop pattern in the foyer. And so if one had a superficial cut on the side of a finger and shook it in the fashion I'm doing, and then Mr. Scheck, let the record reflect I'm shaking my hand down, does that create the Kastorf pattern? Yes. And that would that be consistent with what you found here? Yes. And could the pattern that you found here be consistent with a superficial cut on the side of the finger? That's talking about all the drops. Answer was consistent with a small volume of blood. Is the pattern that you see here consistent with a major cut? No. So you have Ms. Clark's speculation, and then you have directly contradictory testimony by Dr. Lee, and there is no testimony in the record that supports her contention. It is mere speculation on her part. She is not a bloodstain expert, and I submit to you, you have to take the sworn uncontradicted testimony. Now, we know from what was said to Dr. Baden that in the course of getting things together on leaving, Mr. Simpson sustained a cut going into the Bronco, retrieving materials on his way out packing, and that it's the position of the defense that the bloodstains that you see and, well, briefly, why don't we pick out that board, and I'll come back to it. This is the prosecution's bloodstain pattern in the Bronco board, if you recall it. Now, there are bloodstain patterns in the handle, instrument panel, the console, of course, and then these are other items. That's the footprint area, and on top of the windowsill, okay? And the windowsill is somewhere around here. That are consistent, everybody agrees, with a cut to the left hand, somebody getting into the car, sitting down looking for something. Consistent with our theory, consistent, arguably, with their theory. But then when you start looking at the rest of the bloodstain patterns, you have to start asking which interpretation is reasonable. Now, the first point that has to be made, take this down for a second, is that, of course, initial deposits would be made by Mr. Simpson that evening, and then somebody else was in that Bronco. Now, we know someone else was in that Bronco, and that's been, I submit to you, demonstrated by the evidence. Let's take a look at this picture. Mr. Cochran has already reviewed with you the testimony of Mark Furman at the preliminary hearing, and you heard it on videotape where he said he found blood in the Bronco, a bit of a Freudian slip. But I submit to you one of the most significant moments has to do with the testimony of Dennis Fung and the bloodstain patterns on the door sill of the Bronco. You recall that Detective Furman testified at the preliminary hearing at this trial that he observed 4 brush mark bloodstain patterns on the door sill of the Bronco that he could observe when the door was closed. When Mr. Fung came in, he circled these pictures. And if you recall his testimony, the bottom circle closest to the door, that's only one stain. He said that that stain could be observed when the door was closed. But the other 3 stains that are represented by those other 2 circles could only be seen when the door was open. Could only be seen when the door was open. From their own witnesses, evidence, he was in the Bronco. And it only makes sense that he would go in that Bronco. And how much credibility do you really put in that man's testimony? But here's evidence that he was in there. You know what other evidence there is? There's one of the most interesting facts, and it's hard scientific evidence that supports our position with respect to the bloodstain pattern in the Bronco, the steering wheel. You recall that the typing on the steering wheel was 1.1, 1.2, a genotype consistent with O.J. Simpson, and 4. Who is the contributor of the 4 allele? That was an issue, and much was made of it in the case, was it not? Lots of cross-examination, lots of highlighting of that 4 allele in the steering wheel. And the prosecution well knew that it was the contention of the defense that Mr. Furman and or other officers had been in the Bronco. Doesn't take much to get a blood sample, or you just take a swab, and the testimony is you run it through somebody's mouth. You can do a quick DQ alpha test. What is Mark Furman's genotype? We know that Andrea Mazzola and Dennis Fung, just like you do eliminations, their genotypes were taken, so we would know what they were. They are not consistent with the 4. None of them has the 4. They're eliminated. Why wasn't Mark Furman eliminated? Why didn't they take exemplars from the police on this? Why? But I think that a fair inference consistent with innocence, which you are under oath obliged to take, you must consider that Mr. Furman was in the Bronco. And the evidence is that a picture, around 4:30 in the evening, he is pointing at that glove at Bundy, walking through a pool of blood. Now, comes in to that Bronco, the vicinity of that Bronco, the area of 5 in the morning, right, initially, then goes out and does his circuitous little trip where he finds the glove and is alone for 15 minutes around 5:30. Now, there's very interesting testimony from Dennis Fung at page 21438 of the transcript about the ground. And he's talking here about Furman, and he's talking about arriving, Van Adder, he's talking about arriving initially at the Rockingham location. And he talks about how he was shown a red stain on the driver's door of the vehicle and a blood trail. And his question, okay, did you notice anything about the temperature at that time or the weather? Answer, it was fairly cool. What about the lawns? Did you notice anything that looked like it could have been dew on the lawns? Answer, I did notice there was some that the grass was wet. Question, all right. So Fung tells us that the grass is wet, but we know that there's no dew. We introduced into evidence under 1280 the weather, and when it was introduced, and you can take this back into the jury room, you can examine the areas that are highlighted in purple. The only thing it doesn't really make much of a difference to be tricky about is Professor McDonald explained all of this, that when you look at the time listing over here, it's standard time, so anytime you see a time, you have to add an hour. But when you look at the temperature and the dew point, you're going to see that the temperature was always many degrees above the dew point. So in other words, when you look through this, you'll see there's no dew. But the grass was wet, and you were at that location, and you noticed the sprinkler heads in the sprinkler system, and right in that area, that grass area where the Bronco was parked, there are 6 sprinkler heads. The grass, a fair inference, was watered regularly at that location. The grass was wet. That's the fact. Now, if you have, as Agent Bodziak indicated, blood that is caked on the inside of your shoe, even if loafers like Mr. Furman in the inside heel area, in your shoe, and then you walk through a wet area and then you step onto the carpet, you're going to get the same kind of pattern that was testified to for the prosecution side in terms of the fibers going into the shoes and getting out blood that would be consistent with the genotype of Nicole Brown Simpson that is found on the carpet of the Bronco. Then we have the issue of the blood stain pattern on the console. Now let me be precise, because when Mr. Cochran was showing you about the 7/10 of a drop of blood, I just want to make sure that I saw even the prosecutors with a quizzical look. But that happened, I think you recall, at the very end of the trial. And that was a testimony of Gary Sims. You recall that he came back, he was testifying about the RFLP tests and the combining of all the stains. And I asked him a series of questions about combining all the stains. That is, the collection on June 14th from the console of 30 and 31, then the August 26 samples, 303, 304, 305. And we talked about the amount of DNA that you would get, with 1 drop containing 1,000 nanograms of high molecular weight DNA. And then when he looked at the amount of DNA, when you combined all the samples, he said that it wasn't over 100. And question, so that is 1/10 of one drop of blood. That's what it is. 100 nanograms, 1/10 of one drop of blood. And he said, qualified it. He said, answer, well, you have to remember with a drop of blood, for example, if you were testing liquid blood, that is not the same as extracting DNA out of the stains worth of one drop of blood. So you're not quite talking apples. You are somewhat talking apples and oranges there, but in terms of the ballpark you're talking about, maybe getting 3/4 of that DNA out, so you can figure it from that. So then I asked him a question, trying to make it English. All right, so what you're basically saying to us is that maybe if you're just dealing with a pristine drop of blood, you wouldn't get 1,000 nanograms, you get 750, answer something like that. Is that what you just said in English? Answer, yes, that's what I said. Okay, so if we were to summarize, and I mean no disrespect, so if we've got about 100 nanograms of DNA and there's 750 nanograms in a drop of blood, can you give me that fraction quickly? That would be about 1/7. Answer, something like that. Okay, so in other words, make it very, very simple. Hard science. When you combine the amount of DNA and you give them all favorable inferences, Gary Sims, their own witness, says, when you look at the smears of blood on the console, it's 7/10 of a drop. And now, how could that be, you're saying? Let's say it's a drop or two. How could that be? Well, that's because, as Dr. Lee explained, that when you have a blood drop and you smear it over a non-absorbent surface, it smears. So it looks, small amount of blood can make a big smear. And of course, Mr. Goldman's contribution to that 7/10 of a drop of blood is at the most 30–40%. That's very, very, very little. And so then you have to ask yourself, does this make any sense? How could so little, even if we assume, how could so little be there? How could so little be there? Ms. Clark was trying to say, well, this is how the blood got there. We know the Rockingham glove had a lot of blood, mostly from Mr. Goldman, some from Nicole Brown Simpson, and that was somehow placed on the side of the console. So that's why we get the little amount of Goldman's DNA that's on the console. That's their theory. Well, that's consistent with Mr. Furman placing the glove in there. It's consistent with even Mr. Furman having handled the glove and getting blood on his sleeve and just searching around the area, or one of the other police officers, and just getting a small smear of it with his sleeve on the console. That's consistent with this evidence. And you know what isn't consistent with this evidence? Think about it. What are they really saying? If Mr. Simpson had committed these murders and he grabbed the glove, as they're saying, with his open left hand, all right, and placed it on the side, well, then in getting into the car, why aren't there mixtures on the window, right? On the window, on all those other drops, everything else, all those other blood stains. There's no trace of blood from either of the victims. There's no mixtures. Wouldn't there be other blood on the hands? And of course, their theory before you, this is extraordinary, is that he's wearing these clothes that we've just been through the evidence of struggle. If there's blood on pants, it's going to be on the seat. If there's blood from the struggle with Goldman, it should be there. We know there's no hair, there's no trace, there's no fibers from clothing, there's no berries. There's nothing in that Bronco that would be consistent with somebody that had committed a violent double homicide, that had been in a life and death struggle with Mr. Goldman. It doesn't make one bit of sense. If you look at the bloodstain pattern in the Bronco, you have to have a reasonable doubt about that. And haven't we shown you by credible, fair, and reasonable evidence that this Detective Furman would have gone in that car and by his own testimony and exposed lies from the prosecution's own witnesses, there's evidence he was there. Those stains on the door sill give up the lie, don't they? He was in that car, and probably more than one of them was in that car. Now, with respect to the credibility of the evidence, very briefly, and I know you followed this, we have to make a distinction. In her opening statement, Ms. Clark actually said to you that all she was going to talk about in her opening statement with respect to the Bronco were the stains that were collected on June 14th. She didn't even indicate they were going to offer you anything from after August 26th because they know how terribly this was handled and that no jury could really accept the integrity of the evidence after this car was abandoned. But could we bring up the board, please, on the 13, I think it's 1351. The DNA board with the... Very briefly, you recall this. And we made a distinction here. We have to look at the samples that were collected on June 14th and the samples that are collected on August 26th, as Dr. Gertie suggested to you. If you look at the June 14th DNA evidence, okay, with samples 30 and 31, nothing in 30, 31, they're calling this faint 1.3 allele, where the 1.3 is showing up in the controls. And you remember the whole business about development length and the notion of controls failing. This is it. From June 14th, this is it with respect to DNA from Mr. Goldman in the Bronco. That's it. And as Dr. Gertie's indicated to you, that is not credible scientific evidence. Of course, they're offering you evidence that was collected on August 26th, after this vehicle was literally abandoned, after the no special care hold had been taken off it, after there was a theft. Now, Mr. Mraz, he wasn't the world's most credible witness on the issue of the theft, but I really think that's besides the point. Number one, he's stealing, he's inside that car. What's going on? He didn't see blood, but you don't have to accept Mraz. What about Detective Moldorfer, who's investigating this? She doesn't see blood. And then there's Mr. Blazzini. He doesn't see blood on the console. And we know that there's all kinds of people allowed into this vehicle, and probably more disturbing than anything else, as Detective Moldorfer indicated, the rules are violated, and there is no record kept of any authorized police personnel, of any police personnel going in and out of there. They could just go in and out and no records were kept and nobody would know, period. And all of a sudden, what we have on August 26th, when the car is finally brought in, and Ms. Clark said it was she must have misspoke when she tried to imply that the inspection of the Bronco was at the request of the defense. Those are not the facts. The facts are that they brought it in, they allowed the two defense people to observe, and then Michelle Kessler looks in the vehicle, and there's a photographer that was brought down from Life magazine at the behest of the police commissioner to witness this grand examination of the Bronco, and lo and behold, they find as much blood on the console on August 26th as there was on June 14th. And then when they do the DNA testing patterns, they find not only traces of Mr. Goldman's blood, but Nicole Brown Simpson's blood in those same areas. That is awfully odd. So the integrity of the evidence, again, is in question here in terms of what you can accept beyond a reasonable doubt. But even if you're willing to look aside from that, and I don't really think that one can, in fairness, I think that the defense version of how the blood got there and the bloodstain pattern in the Bronco is far more plausible than the prosecution's version. It just doesn't fit. There would be mixtures on all those stains according to their own theory. There should be more blood in the Bronco, given what occurred in this case. The bloodstain patterns don't make sense, do they? They really don't. And nor does the hair and fiber in that Bronco. Now, let's talk about the glove. The first point to be made about the glove is an integrity issue. And that is that you recall that when Mr. Yamauchi opened up the reference tube in the morning and spilled out the blood, the first thing he did after that was this examination of the Rockingham glove. And as you recall, he was putting his initials in, he was doing all these phenotesting, these manipulations, all in the wrist area of the glove and manipulating it. There is so little DNA in these few areas here from the D1S80 tested, minuscule nanogram amounts, very, very small, consistent with a small sample handling transfer from Mr. Yamauchi. And that alone, I think, can explain the small amount of DNA on the glove. But of course, under the other scenarios, the competing scenarios of the defense and the prosecution, if the Rockingham glove was up against the side of the console, that certainly would, of course, explain a small transfer of Mr. Simpson's blood into the heel area of the glove. But you know what doesn't make sense? What doesn't make sense is their theory. First of all, the tight glove is thrown off from the left hand in the course of the struggle. But they're saying that with a cut, a bleeding cut, the fish hook on the knuckle, which nobody sees on the way to Chicago, and blood on this hand, the gloves are taken off. Can they really suggest to you that gloves are taken off at the wrist? I'm from back east Brooklyn, you know, I wear a lot of gloves. You may not have as much experience. But think about it. You don't take gloves off like this, you take them off like that. And you know what? That's exactly what the criminalists were thinking. That's what Gareth Sims was thinking. Even Mr. Yamauchi was thinking that. Because most of the initial DNA testing all was done looking for blood on the fingers, top fingers of the glove. Because that's all that makes sense. And there was nothing there. And that's got to give you, I would submit, a reasonable doubt. So what I've tried to do in my remarks is review with you essential pieces, circumstantial evidence of the prosecution's case. And we don't have to do that. We don't have the burden of proof in this case. And each essential piece, I think it's fair to say there's a reasonable doubt. And some of these are so profoundly disturbing in terms of the manufacturing of evidence in this case that I'm sure you really can't abide it. Not in this country, not in this democracy, can we allow dishonest, manufactured evidence to lie at the heart of a case like this. It cannot be. You cannot trust. I mean, you cannot go back and say, well, maybe they planted evidence on the glove, maybe on the back gate. Oh, there's blood missing. Big deal. How can that be a big deal? There's many, many reasonable doubts embedded in all of that. But you know, there's a fourth C. Contaminated, compromised, and corrupted. But there's a fourth C that goes along with how these things happen that relates to this forensic testimony. And the fourth C has to do with cover-up. And I'm not even talking about the statements of the police officers and the cover-up of Mr. Furman that Mr. Cochran has discussed with you so eloquently in the last 2 days. Let's just talk a little bit about the criminalists and what you can view in terms of that evidence and how that affects on their credibility, because if you lie in small things, and some of these are not so small things, you lie in big things. And if you're trying to turn the other way and cover up real problems, serious problems, you can't abide it. Now, one I alluded to early, and I just think it goes to the heart of the hair and fiber evidence and so much in this case. And your common sense tells you. They moved Mr. Goldman's body. They were traipsing around that crime scene. And we know the envelope was moved, and we know the glove was moved, and somebody put it back. And remember, Mr. Fung, they actually have a form. If the scene was altered, you know, describe how. And Mr. Fung says, it's not my job. We don't ask. Detective Lang, do you know? I don't know. Did anybody ask Jacobo or Ratcliffe, the coroners? Did anybody come in and do an investigation? Isn't it important to know who's moving around this evidence, that they're going to come in and make a big deal about hair and fiber and other things? Don't we have to know that? Isn't that just fair dealing with you? And how can, I mean, they're covering this up. They're covering up how miserably this was handled and how the integrity of the evidence was compromised. It's as plain as day. It's an insult to your intelligence to say otherwise. Why? They have a responsibility to come in here and do that. And we looked at videos where I submit to you there's a glove on the blanket that somebody put back. And then there was the testimony, you know, Detective Lang said, and if this isn't covering, I don't know what is. Well, why did you move the bodies? Why did you wait so long to bring the criminalists in? Why did you move the bodies before you collected the evidence? Because that's lunacy. And the answer was, this is what you call a closed-in crime scene. And in a closed-in crime scene where the evidence is close to the bodies, the first thing you do is move the bodies? That was a makeup. It was nonsense. As all the other criminals who came in here and testified, even Mr. Fung couldn't abide that, because it's covering for mistakes. Now, another one is just the whole way it went. Mr. Fung, when he testified in the grand jury, and initially at the preliminary hearing, he forgot Andrea Mazzola was there with him because she was a trainee and she played a big role in this case in handling the evidence, and they wanted to forget it ever happened. And, you know, that's the way it was. And, you know, when I asked him, well, was there any concern in the lab about this before you went to testify in the grand jury of the preliminary hearing? No. It's just this habit I have of saying I when I mean we. It's a habit of testifying. But, you know, when Ms. Kessler came here, she was actually asked by Mr. Neufeld, was there any discussion before Mr. Fung testified in the grand jury about what went on in this case? And they said, well, there was some concern that Ms. Mazzola was listed on the forms as the officer in charge. And I think that tells you all you need to know. Of course they were concerned about that because they realized that the whole scene had been miserably botched. And there were serious problems here with the integrity of this evidence. Then, of course, there was the handoff of the envelope, and just as a quality of testimony. I mean, Mr. Fung said, oh, I wouldn't take that envelope, pick up that envelope with my bare hands, and then we showed it to him on videotape where he's picking up the envelope with his bare hands, and then he goes, well, that couldn't have happened because the coroner, Mr. Jacobo, wasn't there, so I have the timing right, and then we showed him the videotape of Mr. Jacobo walking by that he was still there. Well, there's something wrong with the quality of testimony like that. There's something wrong when Ms. Mazzola conveniently begins to close her eyes because problems arise on how the trash bag is carrying this blood vial out sitting on the couch. There's problems with the whole trash bag story. There's problems, there's an extraordinary problem with Ms. Mazzola suddenly forgetting that her initials are on the bindles. And the only credible testimony is that they were there and something's wrong. So when something's wrong, people's memories get selective and testimony comes in funny ways. Dr. Goldman, the coroner, never showed up. Mr. Martz destroyed his underlying digital data and didn't save much of the data. Mr. Martz stopped looking in terms of testing. Mr. Rubin stopped looking pretty early. We have an EAP exclusion on the fingernails that they're desperately trying to change. And then, of course, there's Ms. Kessler can't even remember the substance of the meetings that were had early in the case about security of the samples. And then that was remarkable. Remember when Ms. Kessler, when we were talking about looking for blood on the sock, and it said blood search not obvious? And then remember that testimony where she said, well, that wasn't a blood search. Well, it says blood search right here. Well, that wasn't a blood search. I mean, some of it was remarkable. And then, of course, there's the Thano-Paradas tape and the missing blood. There's a lot of it. I'm sure you remember more than I've just listed. Ladies and gentlemen of the jury, I thank you very much for your patience. I've tried to reason through this evidence, drawing the fair inferences as best we could, looking at the integrity of the evidence, and I just think there's very little question here, is there? So much of the essential facts in this case are just shot through with reasonable doubt. There is something wrong. There's something terribly wrong about this evidence. Somebody manufactured evidence in this case. There's missing blood. There's EDTA. There's questions, serious, deeply troubling questions. You must distrust it. You have to distrust it. You cannot render a verdict in this case of beyond a reasonable doubt on this kind of evidence. Because if you do, no one's safe. No one. The Constitution means nothing. This cannot, will not, shall not happen in this country with you good people. It just won't. Thank you very much.
Thank you, Mr. Scheck. You want to take a change over here?
Just 3 minutes or so.
All right. Ladies and gentlemen, let me ask you to just step back into the jury room. Probably be about 5 minutes. Let the record reflect that we've now been rejoined by all our jury members. And Mr. Cochran, you may make your concluding remarks.
Thank you, Your Honor. Judge Ito. Again, to my colleagues, good afternoon. Again, ladies and gentlemen. Seems like we did this yesterday. But I won't be nearly as long this time. I'm back, as I promised you I'd come back, to try and wrap up the defense discussion of the evidence with you. You just heard what I believe was a remarkable discussion by Mr. Barry Scheck, an excellent lawyer. He may be from Brooklyn, but he's become a Californian as far as we're concerned. He is a very valued member of our team of defense lawyers for Mr. O.J. Simpson. And you see why. This is indeed a talented lawyer. And so he shared with you a number of things which I will not be redundant about and go over. You have them clear in mind. And if I were not to say anything else, there are many reasonable doubts in this case, and O.J. Simpson is entitled to an acquittal based on what we have told you. This is my last chance, of course, to speak to you, and I want to take this time to tell you again that the prosecution, because they bear the burden of proving this case beyond a reasonable doubt, will have the opportunity to speak to you last. We may not be here too late tonight because I'm not going to be much longer, and I think that more than likely, I think we can probably guarantee this case is going to get to you sometime tomorrow afternoon, so you can kind of sit back and relax. It's been a long, long, long road to get to this point. It's been kind of like a relay race, hasn't it been, in many respects, in this journey toward justice. The prosecution was first running with it. We then took the baton and we started running with it. We've run almost up to the jury box. And soon, we're going to pass the baton to you. This is how our system works. This is what makes it so great. We pass the baton to you, and we'll be glad we can then sit back and watch you at work. You watched us for a year, 2 or 3 days. Now we get to watch you. It'll be symbolically watching you because we won't see you back in that room, but you know we're going to be counting on you, giving both sides the benefit of your individual opinion. Now it's your time to perform. You know how you could think about us in those days when you wanted to criticize us? We're not going to criticize you, though. We're going to just watch you work. And watching you work is what makes this country so great. Because it's 12 citizens, good and true, coming together from this community from disparate backgrounds. Experience not required. Citizenship, the only requirement. To do justice, to do right, to right some wrongs, to straighten this out. That's what we're asking you to do. To follow the law, determine the facts, and come to a well-reasoned decision. That's what's going to happen tomorrow afternoon for you. Now, it may take 1 day or 100 days, but you've been committed. I know that you'll stay the course, keep your eye on the prize, and do the right thing. Now, when I sit down this time, I won't get another chance to argue to you or discuss the inferences because it has to stop sometime. But Ms. Clark gets to talk to you later tonight or tomorrow. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Scheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we got to keep it in line. But if it's a point that we can't respond to, you substitute your wisdom and common sense as to any point. I think you know by this time we can answer anything that they would say. So I'm sure you'll give her the same attention you've given us today, and I wish them good luck. In fact, let me say this. In this case, we have been advocates. We have fought hard, I hope. But it's not personal. What is personal is this case. What is personal is our zeal and our desire that our client be acquitted. It's not personal against these prosecutors. In this part of our discussion, I want to share a couple of things with you and clear up a couple of things if I might. Remember, I was examining Detective Lang, and it was interesting that we saw Detective Lang here today. That's interesting, isn't it? Detective Lang was here. He's the only one who can really come anymore. We discussed the roles of these people. He's the only one who's going to show his face here, you can count on. But Lang says that early on that I asked him questions about traveling around the world to investigate this case, to get an idea of what resources were they putting on this case. You remember right at the very outset, the reason that robbery homicide was put on the case was because downtown they supposedly had better resources. There's some doubt about that, but they did that, and they put resources, including everybody in the LAPD. They had the DA's office and their investigators. They've had the FBI. They've been all over the world. You know, they've been everywhere looking for Bruno Magli's shoes. They've been to Italy. They've been to many of the states in the United States. And I asked them about those things to give you a scope of what they were trying to do. And, you know, it's awesome, the power of the state. And at one point I worked as the assistant district attorney, so I know about power of the state. There's no priority to being on this side. I used to be on this side. You can be on both sides. Perhaps gives you a little different, a balanced perspective. But they have a lot of power. They can do a lot of things. They have a lot of resources. And they've used them in this case. So don't feel sorry for them. They've used every resource they had. When they didn't call people, there was a reason for it. It wasn't they didn't have the resources. These are excellent lawyers. They know the facts. If they didn't disprove something, if they couldn't disprove Henry Lee, if they didn't call anybody for John Gerdes, it's because they couldn't find anybody. Earlier, I talked to you about Detective Furman on this particular point. I wanted to make sure so we could be as accurate as possible. This question was asked by Bailey. There is a problem that has been brought to your attention, isn't there, Detective Furman? Answer, no. Question, when discussing this event in the preliminary hearing and talking about the glove, your tongue slipped and you said them, didn't you? Answer, yes. In case there was any question about what we'd said earlier, Mr. Scheck has covered the brush marks on the door, but what I'd like for you to do is look back at your notes, because Furman said that regarding these brush marks, he said he saw these marks on that door while the door of the Bronco was closed, remember? And the reason why this has become so important was he was trying to say he hadn't gotten inside. Then we called Larry Regal, who said you couldn't see the ones at the top unless the door was open. And then Furman also had said that he told Fung about these brush marks. If you look at Fung's testimony, I think you'll find that Fung never says that he heard that from Furman. And so, you know, with regard to Furman, I could have gone on and on and on about lies, but that would be counterproductive after a while because you know who he is now. There's one other point I wanted to share with you about Furman before we take our leave of him, is that there was some questions in counsel at 18906 about opportunity for Detective Furman. And here was a series of quick questions. When you arrived at the scene this night, were you wearing a coat, a jacket of some sort? When I first arrived at the scene, yes. Can you describe it? Answer, a blue blazer. All right. And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove. Yes, tan slacks. Okay, now, at some point, did you walk back to your vehicle and take off your blazer and hang it to lay in the vehicle somewhere? Yes, sir. Okay. Can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10, that's a.m.? It would be after I was relieved from the case. Now, he's relieved a short time after he gets there. He's relieved by 3 o'clock, isn't he? Before 3 o'clock. All right. That would be close to 3 o'clock? Yes, sir. Question. And that is when you walked back to the vehicle and left the jacket and stood waiting for your relief? Yes, sir. Now, I don't believe hardly anything he says, except that it is true that in this photograph taken at 4:30 or before sunrise, the one you saw where he's pointing at the glove, he doesn't have a jacket on. So he had a jacket, went to that car by himself. There's many things in that car. This man had ample opportunity to get up to that scene. You know, as I told you, it so stretches the credulity to believe that so neatly placed were this knit hat and this glove. Were there two gloves at some point? When he says, I saw them, why would you say them? There weren't two gloves. And, you know, it's so unusual because everything else is spread all out. This was a vicious fight. There's a beeper over here and there's keys over there. But these items are right there, right where you could point at them. It's too packed. So you can ask yourself those questions when you go back into that jury room. Now, in this case, I discussed with you Miss Juanita Moore, a lady that I called to the stand, and I think I misspoke myself. I think I mentioned to you that, I think I may have said, she said that Mr. Simpson did not have dandruff, and if I did say that, I got that wrong. She said that Mr. Simpson would get dandruff, I think, in the off-season, in the spring and summer when he was here, as opposed to when he was in New York, and I wanted to make sure, in looking at the transcript over the lunch hour, I noted that. Ms. Clark seemed to be amazed when Mr. Scheck said that Kelly Moldorfer said that she didn't see blood in that Bronco, so to save her some time, I'm going to read you the transcript. Kelly Moldorfer at 38268, lines 26 through line 9, I think at 38269. Question, and when you looked at the console, do you remember seeing any blood there? Answer, no, I don't have any specific recollection. That's the lady, the investigator, who was looking at this. And so now we come to some jury instructions, which I think have some real relevance as we conclude this case, hopefully. We've already talked about a witness willfully false. We've talked an awful lot. You now know a lot about circumstantial evidence, and I dare say you know the difference between direct and circumstantial evidence. We won't talk further about that. And you know what happens where the proof circumstances are equally consistent, one of which points to innocence, the other which points to guilt, where they're both reasonable. You must adopt that which points to innocence. And you understand that. You understand about circumstantial evidence, so enough about that. And we've displayed this, and we talked about how this works and how it inures to the benefit of the defendant because there's this burden of proof. But there's another instruction which I want to talk to you about now, and this is one where the prosecutors keep wanting to change things around and ask what we proved and what we didn't do. This is what the law is. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was a perpetrator of any such crimes. There's no doubt about that among any of us, is it? The defendant is not required to prove him or herself innocent or to prove that another person committed the crimes charged. So now, if that's what the law is, and the judge gave you that, or Mr. Darden asked the question, who did this? Who committed this crime? Why would he ask that when the judge just said, the defendant doesn't have to show anything? And we know in this case, they rushed to judgment, they didn't look at anybody else. That's a question he should be asking these detectives, not us. We're the ones who had the preeminent experts who wanted to help out. They wouldn't accept them. Could he ask us that question? How could he ask us that question in good faith? So what the answer is, you go ask your detectives. That's the answer. Now, he asked another question. He said, well, where was O.J. Simpson? And he says, well, you know, how does he account for his whereabouts after 10 o'clock? Well, let me just take a minute about this. He asked that question. So let me answer it for you and for him. Some of you in your former life probably lived alone. If you lived alone, if something happened between 10 o'clock and 6 o'clock in the morning, it's real difficult, if you live alone, to prove where you were. Nobody lives there with you. Isn't that true? Is that common sense? Mr. Simpson lived alone. But we've done more than that. We can establish where he was. He was at home. That Bronco was outside. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was getting golf shoes and whatever goes with golf if you're a golfer. That's what he's doing. He's getting this little knapsack out that has golf balls in it. And he was bringing another bag down, all of which were ready when Park and Cato were out there. And he comes down with the other bag, carrying it. That's what he was doing, Mr. Darden. That's where he was. It's your speculation. He's on the side of his house running into an air conditioning. That didn't happen. That's unreasonable. Nobody here believes it. It's not going to help save their case. They're speculating again. Speculating. Cynically speculating. And it's not going to work. And so that brings me to this other instruction. It's called alibi. You remember during voir dire I asked you about this. I said that you won't place a bad connotation on the term alibi. That's what the law calls it, alibi. And it says as follows, that evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Can I repeat that last part for you? If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed. It doesn't say you might find him not guilty. You might think about it. It says you must find him not guilty. And so, you know, when you talk about this whole concept of reasonable doubt, and we'll talk a little more about that, it's how you feel inside about this evidence. It's how you feel inside about these messengers and their message. It's when you have that queasy feeling. You can't trust this evidence. Barry Scheck described it well as a cancer. He talked about one cockroach you don't need to see anymore, because you know if you see one, there's a lot of them around. All you need is one, and that's going to make you go the other way. In this case, you don't have to get past the socks. But then you get to the glove and the Bronco, and you get to all of it, none of which you can trust. And then how do you do it? Do you get back there and say, well, I don't trust him on this. I think I can trust him on that. When the essential link in the chain is broken, you got reasonable doubt. And so your job won't be quite as tough as you may have thought. Reasonable doubt? In this case, the prosecution has not offered one coherent theory to explain how these deaths occurred. I won't talk about thanatophoritis and the desperation that brought about, but let me talk to you about this whole concept of what took place in this case. One of the things that was intriguing to me, and I'm sure you've thought about it, and I know that your collective minds are far better than mine and Mr. Scheck's, but you know, we think about things that will be helpful to you. You know, one of the things that's always troubled me about the prosecution's case is, you probably thought about this, Cato the dog was purchased by O.J. Simpson after the other dog died. Remember, Arnell told you about how they had to bury the dog, and it was a real tough time for the kids and all. O.J. had that dog, Cato, along with Chachi, the other dog, over at Rockingham. And he let his son have the dog because they named the dog after Cato, who is now living over with O.J. Simpson. That dog knows O.J. Simpson. It's his dog. He bought the dog. They didn't know this as they were speculating. It's his dog. If O.J. Simpson had been the one there that night, that dog would have followed him out the back gate. He wouldn't be going out the front. Those paw prints wouldn't be going out that way and down the sidewalk saw. That's common sense. They said use your common sense. They make sense to you. The other thing is, the one thing that you can count on in this case is these two people, even when they weren't getting along, loved their children. And their children loved them. Whether it was pediatric AIDS affairs, whether it was recitals, whether it was sunshine preschool affairs, just look at the month of May, the things that you heard that O.J. Simpson went to. Always on the weekend because he was traveling. Wasn't no fuse, he was out of town working. He was the breadwinner. So whether it was the pediatric AIDS or something for his children's school at 400 people over at the Rockingham estate, he was always there for the kids. If it meant coming back from Chicago on Friday or from wherever he was in New York on Friday to go back to Chicago on Sunday to go back for an engagement, he came home. He came home because his little girl was having a concert. That's the kind of dad he is, and somebody has to stand up for him. People don't want you to stand up for him. People can't stand the truth, but they're going to hear truth in here. There's one place you can't take away somebody's voice, and that's in the courtroom. When you want to tell the truth. For 16 months, this man sat over here and heard people talk about him day in and day out, judged him and prejudged him against the American way. What right? How dare them do that? And he has 1 day or 2 days to have somebody stand up for him, and people are crying and moaning. It's outrageous in America. It's intolerable, if you will. And so this is a good and decent man who loves his family, loves his kids. None of us are perfect, but he's a man who went a long, long way. Raised primarily by his mother, you know what he did with his life. He had a good life, a wonderful life. He's done well. He's not going to give all that up, try and kill somebody with a knife. He's not going to give that up. And you know what? As you think about this case, can you imagine that a man who loves his children so much is going to go over, kill his ex-wife, kill their mother, and leave her so that the children can come downstairs and find her? That defies credulity. None of you believe he would do that. It's contrary to everything that you can believe and that you've heard about this man and what he's done and what he's done with his life. So forgive me if I speak out for O.J. Simpson. If I'm so presumptuous as to believe that the Constitution means that you're presumed to be innocent until you make the decision. Nobody outside here has a vote. You have that vote, thank heaven. These narrow-minded people, thank heaven they don't have a vote. You will have the final say. And so, this concept then of reasonable doubt. What then does it mean? We've heard about it. We've talked about it. We have a chart. I'm going to ask Mr. Douglas to put over there. Let's talk about this whole idea of burden of proof and reasonable doubt and what is reasonable doubt. You remember during voir dire, I talked to you about this concept of reasonable doubt, and before we go to that chart, I mean, it's that state of the case after the entire comparison and consideration of the evidence leaves the minds of the jury in that condition where they cannot say they feel an abiding conviction of the truth of the charge. That's what reasonable doubt is, and let's go over it one more time because this is the cornerstone of every criminal case. What it really is a doubt based upon a reason. In this case, we have given you myriad reasons. There are many, 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 many reasonable doubts. It's not just one, all of which lead you to one verdict in this case and one verdict only of not guilty, but let's go over it one last time together. A defendant in a criminal case is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving him guilty beyond a reasonable doubt. You've heard a lot about that. That's what people need to learn and be reminded of in this country. Reasonable doubt is defined as follows. It is not a mere possible doubt, and we know that, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where, after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that conviction, that they cannot say they feel an abiding conviction of the truth of the charge. That's reasonable doubt. It's not written just for O.J. Simpson. It's for you. It's for you. It's for you. It's for all of us who are citizens. It's given in every criminal case. You have to give it. That's the burden. You don't change it once the trial starts. That's the burden. Let's see how it works. In this whole idea of a burden of proof, let's start down at the bottom and look at the burden that's placed upon the state. And they should have a burden like this. You're talking about taking somebody's freedom for the rest of their life or whatever. There are a number of things that you might want to think, but in a case, sometimes in cases, we actually can prove the person charged not guilty. And in this case, in my 32 and a half years, this may be as close as any case where somebody's been proven not guilty, because if you look at these facts, you look at what we've shared with you over the course of the last 2 days, this man has been proven not guilty. But that's at the very bottom of the rung. You may say, somebody among you may say, well, you know, I have some suspicions. I think it's highly unlikely, but I have some suspicions. Somebody else may say, well, it's less than likely, but, you know, I don't know. I mean, they didn't convince me beyond a reasonable doubt. And somebody else might say, well, you know, he's probably not guilty based upon this evidence. Somebody else will say, it's unlikely he's guilty. No way in the world is he ever going to go over and kill the mother of his children under these circumstances. That the timeline shatters their case. Somebody said, I don't trust the police. Furman was central. I don't trust Van Adder. It's the messengers and their message. It just doesn't fit. Something's wrong. There's a cancer here. Possibly not. Guilty? Maybe not. As Mr. Scheck said to you, you know, maybe not's not good enough. You're talking about somebody's freedom for the rest of their lives. Well, then somebody else may say, well, perhaps, gee, I don't know. I suspect that he might be. Maybe he's possibly guilty of something. Maybe he's probably guilty. Maybe guilt is likely. Maybe guilt may be highly likely. I don't think any of you are going to find this case, because I think we've shown that we've proven he's not guilty. But all of those levels, from proven not guilty to the guilt highly likely, is our interpretation of what you have to do before you get all the way up to guilt beyond a reasonable doubt, so that you won't have that queasy feeling about this case, where you can believe to an abiding conviction of the truth of these charges. Can you have that? I think not on this evidence. Not on this evidence. Not on this case. They have failed. You know, we ask you a question. Did you have the courage? Did you have the intestinal fortitude to walk back into this courtroom? If they fail to prove Mr. Simpson guilty, you have the courage to walk back in here and say, we find him not guilty, and you said you could do that. That was part of your job. You said you could do that. We're going to hold you to that because that's what makes the system great. Your courage, your willingness to stand up for what is right. And so, in this scenario, thinking about reasonable doubt even more, the prosecution had a puzzle. And it was interesting how they did this puzzle. Technology is wonderful, and you saw they kept under this puzzle putting on pieces and that sort of thing. And so we thought about that. I thought about this puzzle, thought about what it meant in this particular case. They got a call from a very, very wise lady who reminded me that if you've ever gone to the store and bought a puzzle, when you buy a puzzle, on the outside of the box of the puzzle, there's a picture. So you know what the puzzle looks like when it's finished. Well, in this case, the prosecution took a photograph or picture of O.J. Simpson first. Then they took the pieces apart. If they really wanted to talk about reasonable doubt, you don't jump to conclusions at the beginning. You don't rush to judgment and then be concerned about an obsession to win. What you do is you take the pieces and put them together, and then you come to the conclusion. They got it all backwards. It's like what they did with the Fourth Amendment. It's like asking us, where is this witness? What did you prove? Solve this crime for us. They got it all backwards. Don't you see? And so that little example, a jigsaw puzzle, was clever, but really it trivializes a man's fight for his freedom, who's always said that he was innocent from day one. So I wanted to just summarize our sense with a graphic, thanks to Mr. Bob Blazer, of this evidence and why there's reasonable doubt as to each of these items. Please note the monitor. All right, let's look at first. We know in the upper left-hand corner, there's missing blood. They can't explain it, and they went down in flames, going out with a home video where it was actually embarrassing this morning. You want a little levity during the tough times in your deliberations? Play the Thanoparatus video. In fact, it's so bizarre that if you listen to it again, you'll hear Hank Goldberg is laughing himself. He starts laughing when, if you look, the words are mouthed by Paratus. He goes like that, and Goldberg starts laughing at his next question. How embarrassing this is, but this blood is still missing. You'll have that syringe there. So Mr. Blazer and Mr. Harris, what does that mean, that missing blood? It means reasonable doubt. Then we have the socks, my personal favorites. And when I talked to you about the socks yesterday, I may not have told you that in addition to the socks not being in the video at 4:13 on June 13th, and how they placed them there later, and how they were collected at 4:35 or between 4:30 and 4:40, Willie Ford came in here and testified to you he didn't see the socks. Forgot to tell you that yesterday. He testified they weren't there either. So thank heaven there's one person who wasn't part of that cover-up, although they got to him and he was saying things, oh, well, the socks may have been covered. But he still works over there. So we'll forgive him for that, but he didn't know what we knew about Lang and Mazzola and the time they were collected in their log. Plus the timing on the whole thing got them. And those straps on the bed further. So what have we shown you about the socks? Reasonable doubt. That moves to the back gate. What about that back gate with the EDTA and more DNA than you could ever imagine, and it's picked up and collected 3 weeks afterwards when people have been all over the place, and you saw the photograph? Look at that photograph. That photograph doesn't show any blood, it shows some little tiny spot. It was totally inconsistent. They're trapped again by the video. This case will go down as the video case because we have shown you for your own eyes why they lose this case, why there is reasonable doubt. So the back gate, reasonable doubt. And then we started out with the timeline because we knew at the outset the timeline with the witnesses that they failed and refused to call establish a reasonable doubt. It shatters the prosecution case. If you start there, you'll find these witnesses credible. O.J. Simpson couldn't have committed these crimes. There's reasonable doubt. He's not guilty. The timeline. We went from there to the EAPB, and you'll remember that, and Mr. Scheck has talked about it. I won't be redundant. The double-banded B, that's somebody else. They can't explain it. They never tried to explain it, except to talk to you about something that's not in the literature. It didn't work. There's reasonable doubt about who that person was. And so, with regard to, and I see I've lost track of my chart there, demeanor, before we get to EAPB, under demeanor, O.J. Simpson's demeanor. All those witnesses who didn't know each other, who you heard, who they talked to, you saw them all. You think that he was acting for those people? And you remember that one of the most interesting things was Mr. Darden said that when the Scott Kennedy video at the June 12th recital, where a man just happens to stop by and takes a video, Simpson doesn't even know he's being videoed. This guy doesn't know Simpson. He's just taking a video. Just came to us out of the blue. They had the audacity to tell you he was on camera. You didn't know anything about being on camera. Somebody's taking a video of you. How do you know that? But we had that video, and they have nothing else to say. You ever notice when they have nothing else to say, how they just say anything? That's an example of that. That's an example of O.J. Simpson's demeanor, and that was our answer to this so-called fuse. We had proof for you. You saw him on that date, and we took you through step by step through that date. We've already covered the EAPB, the Bundy blood drops that Mr. Scheck did such a great job on, and you know about those drops. You know the numbers as well as we do, and I won't go over those anymore. I think there's reasonable doubt based upon those, and of course you know the Bronco. How can you trust the Bronco? Chain of custody, how can you trust it? There's nothing you can trust about that Bronco and how they handle it. And then the gloves. The gloves didn't fit. The gloves didn't fit. The gloves didn't fit. Reasonable doubt. And then the why. Now, motive is not an element of the crime of murder, but absence of motive would tend to establish innocence. That's why Mr. Darden went to such a long and exhaustive study. And I've shared with you the fact that there is no motive in this case, but I just want to briefly tell you about their theory at the end. If you believe what the prosecutors want you to believe, you have to believe that O.J. Simpson, who has a limo driver coming, I guess around 10:30 or 10:40, after he goes and gets a hamburger at McDonald's, after having been worried about change because he had $100 bills, that he's already been packing because clothes are being brought down, and he's taking his golf clubs because he is going to play golf, and that makes sense as a pre-planned trip. He's just off the road and going back on the road. That he is perhaps the most recognizable person in Brentwood in that area where he's lived, we know, for 17 years. That he drives a white Bronco. That he decides to put on a knit cap, and you saw that exhibition yesterday of him or you or I in a knit cap. He decides he'll put that on. He changes out of his tennis shoes, his Reebok tennis shoes, and his sweat socks, and puts on some dress socks, and puts on some Bruno Magli shoes. And let me just stop right there for a minute, put a pin in that. The Bruno Magli shoes, you heard all about Bruno Magli shoes and Bruno Magli shoes, and we searched all around the world, and we went to Bloomingdale's, and what did we find? There is nobody who ever sold O.J. Simpson any Bruno Magli shoes. They searched, they tried, they never sold him any shoes. So they just been talking about Bruno Magli shoes. I mean, there must be every other house in Brentwood. If somebody wanted to afford some Bruno Magli shoes, I guess they could. Now that's their case. There is no evidence that O.J. Simpson had any Bruno Magli shoes ever. In fact, when Lang is looking for the clothes and O.J. Simpson says, this is what I wore, here are the tennis shoes, he took only tennis shoes that night. There is no evidence that O.J. Simpson ever owned any Bruno Magli shoes, and please remember that. So he puts these Bruno Magli shoes on, and he's trying to disguise himself, of course. He puts on a pair of gloves that don't fit, and he gets in his car, and he decides that what he'll do is he'll drive over to the alleyway behind Bundy where his wife lives, in this big Bronco. Now, while he's going to do that, he's been over there a number of times, and you know they've already told you about Pablo Fenves and these people who live back there. You remember when you went on that jury view? There are homes and windows and things that face down on that alley, on both sides. From, I guess, Gretna Green side and from the Bundy side. People are looking down in that alley. It's well lit. You saw the photograph yesterday of what Mark Storfer would have seen. He pulls into this alleyway in this Bronco, in this disguise, dressed the way they want to have him dressed. So he's come and kill his wife. Now, somehow, in trying to kill his wife or whatever, he doesn't kill her in the back there where the car is. He goes and lures her to the front gate. Doesn't make any sense, does it? He goes to the front gate to lure her to that front gate. And then he gets into a fight, somebody he doesn't even know. This fight goes on for 5 to 15 minutes. The fight is so fierce that a hat and a glove are torn off. That's how fierce this fight had to be. The keys, the beeper. You saw how tough it is for any kind of an altercation. For gloves to come off, for a hat to come off. There's kicking, there's all kind of fighting in this small area. But that's what they want you to believe. And so we find the keys and the beeper and the gloves, of course, we find specifically the cap and the gloves neatly packaged under the item there. And then he leaves this one glove behind and then just walks slowly out to the alleyway. Now, the dog that we heard so much about, who he bought, who was his dog, doesn't go with him. He goes the other way, out the front to go down the other way. Cato, the dog, under what they would have you believe. And he's got these bloody clothes on and everything. Now he goes back out there where his car has been sitting 10, 15, 20 minutes, right out there in the alleyway. Anybody could look, anybody coming home, people are driving up and down the street. Gets back in his car, then presumably he races back home where the limousine driver who's there doesn't hear him come up, doesn't see him, doesn't do any of those things. And we know from the time they see O.J. Simpson, within 5 minutes, he's coming downstairs, packed, luggage is already down there, looking neat as a pin, heading for the airport. Now, he was expecting this man after he came back from the hamburger. This is what their case is. This is what they want you to believe. And just for good measure, it's not enough. That's not enough. Under their scenario, once he gets home, after he's rushing, he's got enough time, he's got all these bloody clothes on, he runs down the side of his house, where he's lived for 17 years, and runs into the air conditioning. It says, oops, no marks, of course, on his body, but while he's back there, he drops a bloody glove to match the other glove found over at Bundy. And just for good measure, so they'll be sure and find it, he knocks on the wall. He doesn't run into the wall, he knocks on the wall. He says, he gives a signal. Then he decides he comes in the house, but nobody sees him do any of that. That's what they have you believe. That is the prosecution's case. We have been here 1 year, ladies and gentlemen, and 2 days to hear this is what they have told you. It just doesn't fit. If it doesn't fit, you must acquit. Something is wrong with the prosecution's case, and your common sense is never going to let you fall for it. So the other side, of course, we submit in answering the questions that O.J. Simpson was at home getting ready for his trip. He had no problem with his ex-wife. He had gone to this concert. She had gotten the tickets for him. There's no argument. Nobody's come in here, so they had any argument that day. There's no fight. They talked earlier, made arrangements for the tickets. He went to the concert. You saw him at the concert. You traced his steps that day and what he did. And then he went on to Chicago and came back immediately. And everything he did was consistent with innocence. This case is a tragedy for everybody. For certainly the victims and their families. For the Simpsons family, they're victims too because they lost the ex-daughter-in-law. For the defendant, he's been in custody since June of 1994 for a crime that he didn't commit. Someone has taken these children's mother. I certainly hope that your decision doesn't take their father and that justice is finally achieved in this case. One final word about Alan Park. We talked a lot about Alan Park. He's somebody that Ms. Clark, of course, found credible. But even credible people don't get everything right. Remember the golf bag? He thought it was a blue golf bag, and we know it's black with an insignia on it. We know that there was a lot of questions asked about whether you saw a car parked at the curb, and I read you the portion that when I questioned him where he said he hadn't really been looking. He was not very clear with regard to that. But like all witnesses, you hold them up to the same standard and look at them. And so now, I promise you we're going to coming to the end. If after hearing all of this evidence, you have a reasonable doubt, it is clear that O.J. Simpson is entitled to an acquittal. And whether it is O.J. or no J, the result would have to be the same. His status doesn't count. It's the evidence that counts and what's been proven to you under these circumstances. But he is a good and decent man who you have seen and observed every day. We're in session since September 26, 1994. Now, as it comes time for me to conclude my remarks, I may never have an opportunity again to speak to you, certainly not in this setting, maybe when the case is over. As you've been told many, many times, there's a very heavy burden placed upon the people, and for good reason. Prove this case beyond a reasonable doubt. As such, it is Ms. Clark's duty to answer for you, as best she can, any legitimate questions arising from the evidence, which we believe casts doubt upon Mr. Simpson's guilt. There may be 1,000 such questions in a case like this, which can be put to her, but we intend no such exercise. I do think, after careful deliberation, that it might be fair to suggest 15 questions, just 15 questions, which literally hang in the air in this courtroom at this moment, and as the time approaches for you to decide this case, for us to hand the baton to you. I offer these questions now as a most important challenge to the prosecution. The prosecution which claims that it's met its burden in this case. If that burden has in fact been met, you will be given logical, sensible, credible, satisfying answers to each of these 15 questions. If the questions are overwhelming and unanswerable, they will be ignored, or you'll be told that the prosecution has no obligation to answer the questions. If you're given anything less than a complete, sensible, and satisfactory response, satisfying you beyond a reasonable doubt to these 15 questions, you will quickly realize that the case really is transparent, and you'll think about the scenario that I just went through for you, and that the term smoke and mirrors that you heard about doesn't apply to the defense. We proved real, hard things for you, things that you can see, things you could take back in that jury room. And accordingly, you'd have to find Mr. Simpson not guilty. When I've concluded, for Ms. Clark's convenience, should she decide to deal with these very troublesome questions, I'm going to leave a written list of these questions here when I conclude. Let me go over these 15 questions with you just briefly. 1, why, they're on the monitor, did the blood show up on the sock almost 2 months after a careful search for evidence? And why, as demonstrated by Dr. Lee and Professor McDonald, was the blood applied when there was no foot in it? Think that's a fair question? In this case, let's see if she can answer that question. Question number 2. Why was Mark Furman, a detective who'd been pushed off the case, the person who went by himself to the Bronco over the fence to interrogate Cato, to discover the glove in the thump, thump, thump area? Number 3, why was the glove still moist when Furman found it if Mr. Simpson had dropped it 7 hours earlier? As Agent Bodziak told you, Sir McDonald has told you, blood dries very rapidly. 4, if Mark Furman would speak so openly about his intense genocidal racism to a relative stranger, such as Kathleen Bell, how many of his co-workers, the other detectives in this case, were also aware that he lied when he denied using the N-word, yet failed to come forward? Part of Barry Scheck's 4th C of continuing cover-up. 5, why did the prosecution not call a single police officer to rebut police photographer Rocard's testimony that Detective Furman was pointing at the glove before Furman went to Rockingham? That is around 4:30 in the morning. 6, if the glove had been dropped on the walkway at Rockingham 10 minutes after the murder, why is there no blood or fiber on that south walkway or on the leaves the glove was resting on? Why is there no blood on the 150 feet of narrow walkway or on the stucco wall abutting it? And you've been back there. Number 7, for what purpose was Van Adder carrying Mr. Simpson's blood in his pocket for 3 hours and a distance of 25 miles instead of booking it down the hall at Parker Center? Number 8, why did Deputy District Attorney Hank Goldberg, in a desperate effort to cover up for the missing 1.5 milliliters of Mr. Simpson's blood, secretly go out to the home of police nurse Thanoparadas without notice to the defense and get him to contradict his previous sworn testimony at both the grand jury and the preliminary hearing? Paradas was never sworn. We were never given notice. 9, why, if according to Ms. Clark, he walked into his own house wearing the murder clothes and shoes, is there not any soil or so much as a smear or drop of blood associated with the victims on the floor, the white carpeting, the doorknobs, the light switches, and his bedding? 10, if Mr. Simpson had just killed Mr. Goldman in a bloody battle involving more than 24 knife wounds where Mr. Goldman remained standing and struggling for several minutes, how come there is less than 7/10 of 1 drop of blood consistent with Mr. Goldman found in the Bronco? Number 11, why, following a bitter struggle allegedly with Mr. Goldman, were there no bruises or marks on O.J. Simpson's body? And you'll have those photographs back in the jury room. Number 12, why do bloodstains with the most DNA not show up until weeks after the murders? Those on the socks, those on the back gate, those are 2 major areas. Number 13, why did Mark Furman lie to us? Why did Phil Van Adder lie to us? And finally, 15, given Professor McDonald's testimony that the gloves would not have shrunk, no matter how much blood was smeared on them, and given that they never shrank from June 21st, 1994 until now, despite having been repeatedly frozen and thawed, how come the gloves just don't fit? I'm going to leave those questions for Ms. Clark, and we'll see what she chooses to do with and about them. That'll be her choice. But I think you have a right to demand answers. If you're going to do your job in this case, it seems to me you will need have answers to those questions. Now, there are many, many, many more, but as with everything in this case, there comes a time when you can only do so much. We took 15 as representatives, but I can tell you we had more than 50 questions. But 15 will be enough, don't you think? I think so. In this case, when we started out a long time ago, we talked a lot about truth. And I always like, in a circular fashion, that you kind of end up where you started out. Truth is a wonderful commodity in the society. Some people can't stand the truth. But you know what? That notwithstanding, we still have to deal with truth in the society. Carlyle said that no lie can live forever. We've seen a number of big lies in this case, in this so-called rush to judgment. We've seen lie after lie, so much so that at least two of the major witnesses, Van Adder and Lang, Van Adder and Strike That and Furman, their testimony by you may be totally disregarded, further dismantling the people's case. You have that right, you know, in this search for truth. In times like these, we often turn to the Bible for some answers to try to figure out, well, you've got situations like this and you want to get an answer and you want to try to understand. I happen to really like the book of Proverbs, and in Proverbs it talks a lot about false witnesses. It says that a false witness shall not be unpunished, and he that speaketh lies shall not escape. That meant a lot to me in this case, because there was Mark Furman, acting like a choir boy, making you believe he was the best witness that walked in here, generally applauded for his wonderful performance. Turns out he was the biggest liar in this courtroom during this process. But the Bible had already told us the answer, that a false witness shall not be unpunished, and he that speaketh lies shall not escape. In that same book, it tells us that a faithful witness will not lie, but a false witness will utter lies. Finally, in Proverbs, it says that he that speaketh truth showeth the forthrightfulness, but a false witness shows deceit. So when we're talking about truth, we're talking about truth and lies and conspiracies and cover-ups. I always think about one of my favorite poems, which I think is so very appropriate for this case. You know, when things are at the darkest, there's always light the next day. In your life, in all of our lives, you have the capacity to transform some of Mr. O.J. Simpson's dark yesterdays into brighter tomorrows. You have that capacity. You have that power in your hand. And James Russell Lowell said it best about wrong and evil. He said that truth forever on the scaffold, wrong forever on the throne, yet that scaffold sways the future, and beyond the dim unknown standeth God within the shadows, keeping watch above his own. You walk with that every day, you carry that with you, and things will come to you, and you will be able to reveal people who come to you in uniforms and high positions who lie and are corrupt. That's what happened in this case. And so the truth is now out. It's now up to you. We're going to pass this baton to you soon. You will do the right thing. You've made a commitment for justice. You'll do the right thing. I will someday go on to other cases, no doubt, as will Ms. Clark and Mr. Dart. Judge Ito will try another case someday, I hope. But this is O.J. Simpson's one day in court. By your decision, you control his very life in your hands. Treat it carefully, treat it fairly, Be fair. Don't be part of this continuing cover-up. Do the right thing, remembering that if it doesn't fit, you must acquit. That if these messengers have lied to you, you can't trust their message. That this has been a search for truth. That no matter how bad it looks, if truth is out there on a scaffold and wrong is in here on the throne, remember that the scaffold always sways the future. And beyond the dim unknown standeth the same God for all people, keeping watch above his own. He watches all of us, and he'll watch you in your decision. Thank you for your attention. God bless you.
Thank you very much, Mr. Cochran. All right, let me see counsel over at the sidebar without the court reporter, please. All right, ladies and gentlemen, contrary to our previous schedule, I'm going to recess for the evening at this time. We will resume tomorrow morning at 9 o'clock. And the lawyers have promised me that we will finish this case. One of the conditions that we go over until tomorrow morning is that we will finish tomorrow afternoon with the rebuttal arguments by the prosecution. I will instruct you, and the case will be yours tomorrow afternoon. And I hopefully we'll at least get it far enough to have you go in, select a foreperson to preside over your deliberations, and then Mrs. Robertson has a list of the exhibits and everything that will be presented to you so you can get organized for the coming days. All right, having said that, please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll see you tomorrow morning, 9 o'clock sharp. All right?